Hello guys, welcome back to Tina Do Children Law Update family. Thank you all so much for pulling up and supporting this channel. You are all amazing. This video is dedicated to those who strive and work hard to ensure the safety of our children, and also to those social care professionals whose work often go unrecognized. We are going to make a shout out for you today. We're going to discuss how the social worker was recognized and praised for the work she was able to do in resolving a family dispute within court proceedings. The social worker here is the children's guardian. And for those of my friends or subscribers who are outside the UK courts often appoint a professional guardian to assess the views of the children and to represent the children in disputes between parents which affects children, and also in other public law proceedings. If you've not yet done so, please click share and subscribe button and click the notification button so you'll receive regular updates. The children's guardian are appointed by the court, and they are professional social workers with a specialty in assisting the court in resolving family disputes. In this video, we're going to look at the commendation given to the children's guardian in a particular case. But before we do so, we will briefly look at the dispute between the parents of the children. And it's a real short synopsis so that it encapsulates the key points. The case relates to the dispute between two parents of two children. The father was found to have been harassing the mother and sending inappropriate letters to the children. The mother had obtained a non-molestation order against the father. The mother separated from the father of the children and has moved on and is now living with another man, and the children are living with their mother and her new partner. The issue before the court was whether there should be ongoing contact between the father and the children, and also the mother wants what we call a section 91 subsection 14 order. What that order does is to prevent the father from continuing or continuously or constantly issuing court litigation over the children. In other words, keep dragging the mother to court for one reason or the other on an ongoing basis. So the matter went to trial, and the judge heard oral testimony from both parents and the children's guardian. At the end of the trial, the court decided to grant the section 91 subsection 14 order, in other words, to restrict what type of litigation or how the litigation can be made. So the court did decide to restrict it, and also made the following pronouncements. The purpose of the order of this case is to give the children respite from the litigation and the stress that go with it. And the purpose is not to send a message that they need not have contact with their father until they are 16 years old. Such an order will be too long. Further, I factored in that towards the expiry of the non-molestation order and the prohibited steps order, the mother will need to return to court for their extension if the need for such order remains. Now, let us now turn to the very good commendation made by the judge towards the children's guardian. And this is a great shout out for those children's guardian doing formidable work in all the courts across the land. The judge said, "It is one of the ironies of this case that the father accuses the guardian of bias and unprofessional conduct, asserting that the guardian is in the mother's camp, when in fact an objective analysis of the evidence is that the guardian has acted to help the father even when it must have been personally difficult to do so because of his harsh and unjustified criticism of the guardian. As is implicit in the previous sentences, I reject the father's criticism of the guardian. She, the guardian, has acted in good faith and with the children at the forefront of her decision making and actions since her appointment. It is telling that it was to the guardian that the father turned to when he reflected on the evidence he gave at the beginning of his hearing. At that point, he had sufficient insight into a need to change if he is to rebuild his relationship with the children. Interestingly, the court went on to adopt the very helpful recommendation of the children's guardian, which was in her assessment report, and the judge adopted them as follows. And I will read it as if it was said by the judge. I consider that both parents would benefit when they attend the Planning Together for Children course recommended by the guardian, and I urge them to do so to enable them to work together in the future for the benefit of their children. Both have said, that is, both parents, both have said during the hearing before me that they will complete the course. I accept the guardian's advice that the father should complete the online course, choosing the teenager modules and the Triple P teen parenting course in person. I consider he will be greatly aided by doing that. Hopefully, on completion, he will have greater insight into his children and their needs. I accept the guardian's recommendation. Let's clap for the guardian. I accept the guardian's recommendation for contact now, and thus affirm that there should be indirect contact by the father, sending to the children one letter a month together with a small gift and a card on special occasions. The mother should encourage the children to write back and to say thank you for any gifts they receive from their father. The father should send the letters and gifts and cards by registered post or similar. That will avoid direct contact between the parents. The mother can and should send a no reply email 4 times a year, to which she attaches a short report on the children for their father's benefit, for the children's father's benefit. That way, the father should be able to stay abreast of important development in the children's lives and will have subject matter that is pertinent to the children for the letters. The father wishes to have telephone contact leading to video contact with his children, which he says he will accept should be supervised. Well, the problem with that progression of contact is that, one, neither child wants it and is thus unlikely to cooperate with it. And secondly, telephone and video contact can be very intrusive. It brings the parent into the child's home. It is hard to proactively monitor. If the father were to speak to either child in the inappropriate term as seen in the earlier letter, the recording would capture what he has said but would not prevent it from being said or the harm that might flow from it. Hence, I reject the father's trajectory plan. Well, I hope you have found, this is me now, I've finished with the comment of the judge. Thank you very much for listening to all I've said. I hope you have found it useful, this update on how the court recognized and gave commendation to the work of the social work guardian, in other words, the children's guardian. And if you want to read the full judgment of this case, the case reference is B and K, re children, contact, section 91, subsection 14, orders, reported in 2024, EWFC from page 167. I'll repeat that. That's B for Bravo and K for Kilo, that's R-E, open brackets, children, contact, when I say colon, I mean 2 dots, section 91, open brackets, 14, close brackets, orders reported in the year 2024 EWFC from page 167. This update news has been provided to you by Tina Do Children Law Updates to enable cross-cooperation between various agencies and ensure that children are properly safeguarded and to ensure that they have a proper childhood. Please let me know what you think about this video in the comments below, and if you have not yet done so, hit the subscribe button. Please make sure you do so. I look forward to seeing you in my next video. Thank you so much.